the continuation of yesterday's regular meeting of the Board of Lane County Commissioners. This is Wednesday, October 9th, 2024. We are in public session, but in our conference room and in a hybrid format for two public works items work sessions. So no decisions will be made today and no orders before us. This is an opportunity for staff to present information that the board has asked to have. And so with that, I will turn it over. Amber, are you leading us through this item or?
Yes.
Oh, sorry. Yes. And I'll just look at the agenda to answer that question. Thank you. I'll turn it over to our planning director, Amber Bell, and also joining us is Ann Davies from our Office of County Counsel. Good morning. Welcome. And thanks for being here.
Thank you, Chair. Good morning, commissioners. So this is a continued work session on type 2 and 3 land use appeal procedures and code amendment options. It's a continuation from the January 23rd and June 26th work sessions. And as you may recall, the last work session in June, there were other items on the agenda, and so the board didn't have the full opportunity to discuss the options and have questions and answers with staff, so it was continued to today. I did want to just take the opportunity to provide a brief overview of what we've been over in January and in June. There's a lot of material to cover. So today I'll provide an overview of the previous elective review procedure, a bit of background regarding the code amendment to change the appeal procedures and eliminate the full elective review procedure that happened in 2019. An overview of the current procedure, a recap of research that we did into other counties' procedures. We looked at 10 other counties' procedures, a recap and discussion of the concept of deference, and we'll be providing some analysis there. And then we'll dive back into potential options and considerations. So a bit about the pre-2019 elective review procedure that we went over in prior discussions. So at a high level, my apologies, this process involved each hearing's official decision coming before the board before an appeal went up to the Land Use Board of Appeals. Appellants could pay about a $3,700 appeal fee for the elect to hear process. And then there were options for refund if the hearings official did not reconsider or if the board opted not to hear the matter. There was also a $950 fee, and that was for the elect not to hear procedure. So that was the more economical option. And then as part of each appeal, there was a number of criteria that had to be addressed. And those criteria are here on the screen. So they are, was the decision made, or can the decision be made within the applicable time limit? Was the appeal issue raised in prior proceedings? And then are issues of countywide significance? Will they recur with frequency? Is there a need for policy guidance? Do they involve impacts to an inventory Goal 5 resource? Or is there a recommendation for review? And then if the criteria were met, the board could approve an order for an on-the-record hearing. And if the criteria were not met, then the board could adopt the hearing's official decision or affirm and choose to affirm the interpretations therein or remain silent on the interpretations. So a little bit about that process is that it was, as we understood some of the board discussion in prior work sessions leading up to the code amendment change, the process was noted to be time, resource, and process intensive. That was kind of the case for all parties. And it was also noted that there was still a need for the board to be involved in appeals that LUBA might afford deference to. The process offered the benefit of the board being able to review the analysis and determine whether the board concurred with whether or not an on-the-record hearing was warranted or not. And so this is just, these are some of the high level discussions that, as we understand them, happened before in those prior work sessions leading up to the code amendment. But there was a good deal of discussion regarding pros and cons associated with changing that criteria at that time. I do think it's important to note that the majority of the time the board ratified the hearing's official decisions. and did not hold an on-the-record hearing. So if we were to apply that trend forward, you would expect to see the same today with the current procedure. And I know there's been some questions about that, and I'm happy to answer any questions about the current procedure.
Just a notation on that, but it was a conscious decision by the board not to weigh in on the hearing official decision.
There was a code amendment that was made in 2019 to make the hearings official decisions a final decision unless the planning director elevates it under the certain criteria.
What is I mean, what do you look for a case to bring to the board?
Yeah, happy to talk about that. So I'll jump ahead a couple of slides here.
Well, if we're gonna get to it, I don't wanna.
So under the current procedure, so again, the planning director can elevate the hearings official decisions on type 2 appeal matters or type 3 applications. It must be done within 12 days. And these are the criteria. So they're really the same criteria, basically copied over from the prior criteria. That is, and there was a little bit of modification. So the criteria are, does the issue involve interpretation of county policies? Is it of countywide significance? Issues that will recur with frequency or for which there's need of policy guidance? Does the issue involve impacts of a goal 5 resource? And then the same director or hearing official recommends review. And so oftentimes, the majority of the time the board did not hold an on the record hearing in that prior procedure. Sometimes there was issues that were before the board elected not to hear. And I know there were some recent appeals where that same issue came up again. So did that answer your question, Commissioner?
So thanks.
Thank you. And so I wanted to mention, because we're talking about options, there were a couple of options that were considered in 2019 when the code was changed, including whether the hearings official reconsideration process should be allowed as a separate step, before it was tied to, as I mentioned, an appellant could file for the elect to hear process. They paid that higher fee, and then the appeal was forwarded to the hearings official. So that process in 2019, the board decided to codify it as a separate step. And then some other options considered were, should there be a local appeal of initial hearings official decisions on type 3 applications, or should the planning director elevate hearings official decisions? And that was an option that was selected. And then I did just want to note, because it's somewhat related to the matter of appeals and who reviews remands from LUBA, is that in 2019, in addition to the amendments to the elective review procedure, amendments were made to the Chapter 14 remand procedures. And so that's 14-100. And specifically, the code had required that for type 2 or 3 decisions, if the board did not hear the matter, that the hearings official would issue a recommendation, and then the board would take some action to render the decision as a final county decision. And then at that time, upon further review of the code, and also because we were looking at that elimination of the elective review procedure, we learned that the board review was not required for type 2 or 3 permits, and it would be sort of an extension, part and parcel of the change to eliminate the elective review procedure would be to change the remand procedure such that a LUBA remand would go back to the final local decision maker, either that be it the hearings official or the board. I'm so sorry, I believe I have an alarm.
So in that case, just when you say go back to the final, whoever had last touched it, basically, whoever
Yes.
last ruled on it.
We talked about the current procedure. just a little bit more there. So I will note that we discussed previously that we can see there's an opportunity for this process to be improved on. Possibly that's refining the criteria. And the board may also have an interest in expanding the appeals that come before the board, of course. To some extent, this criteria, the interpretation of county policies, addresses the issue of which appeals might there be an opportunity for the county to retain deference on at LUBA. But we would offer that perhaps this could be further refined to speak to policies and regulations that are locally adopted, that don't merely implement state law, as getting at what could the county retain deference on before LUBA. And then also possible revisions to this might include making the code more clear and objective, more user-friendly, and making it clear what matters come before the board for all parties. So then we researched 10 counties' procedures, and that wasn't a randomized sample. We tried to look at comparator counties, nearby counties, and a couple of coastal counties. And of those, we found that about 4 have some sort of call-up procedure, and they have some different variations to that. So I'm kind of using that as like a common term. But the variations to that we found are, there's one example where the board can make the initial decision on any land use permit. So they reserve the right to call up a type 1 or a type 2 procedure, for example. Another version of this is that decisions can be brought before the board during the appeal period. So during that 12-day appeal period, staff brings the decisions before the board, they review them, and then they decide whether or not to call them up for further review. We understand that these 2 versions they have been utilized in some counties. Some counties have them in their codes, and they're not utilized frequently. Overall, it's generally not a common procedure. And then another is specific kinds of applications, like a type 3 procedure can be elevated.
Excuse me, Amber, Commissioner Farrar has a question.
And this is a kind of a joint question. The 2 counties, did you mention the 2 counties where the planning commission decisions are final?
Yes,
Which
I
2?
believe it's Washington and Multnomah.
The 2 biggest counties in the state. Okay, all right. By far the biggest counties in the state. Okay.
So then 2 counties have procedure types, including code interpretations that can be elevated to the board. There's one that originates with the hearings official and then or planning commission, and then they're appealed up from there, can be appealed up from there. And then 3 or 4 counties have decisions like planning commission or type 3 or conditional use permits, which are usually involving multiple complex criteria or more impacts that can be appealed forward.
Same question.
Yeah, and even more globally, not to interrupt, but maybe one, could you provide these slides when we're done today for commissioners, just so we can refer back to them, and then the breakdown of which were the 10 counties and how they each fall here. I mean, please answer the commissioner's question here and now, but to have that later in writing would be really helpful.
Yeah.
Thank you.
The types that have conditional use permits that can be elevated, or excuse me, the counties, which counties have specific types that can be elevated, I believe was your question.
Yeah.
I believe if Lynn County, and I'll go back to my notes, I'm happy to circle back to that.
Okay. But it's not Multnomah or Washington, clearly.
No.
Right,
not
okay.
Multnomah
And I'm
or
just kind of looking at a global picture, so thank you.
And then we talked about the couple that have final decisions at the hearings official or planning commission level already. So we have that little bit of extra piece on top of that from those 2 examples. But just to provide those examples. So then on deference, and I'll turn it over to Anne in a minute here. So the board's heard a lot about the topic. Oh, thanks. So the board's heard a lot about the concept of deference and what it can provide, suggesting perhaps that the it provides the board with a good deal of latitude to adopt land use regulations. So this is the statutory definition of deference, and when LUBA will afford deference and when it will not. And so there's pretty specific criteria. So I think I'll turn it over to Anne at this point to talk about the different levels of deference and what.
Yeah, so if there are any questions while I'm speaking, go ahead and shoot, wanting to answer any questions you have. So what Amber asked me to do is kind of give a background information. You guys have heard deference, too many times to even think about probably, but it's a lot of what's central to this decision that you're trying to make is like, when do we want to have things go to the board so that the board can actually have that added deference before LUBA? So we just felt like it was important to kind of step back, and a lot of people say deference, but digging into what exactly does that mean. So this statute, I looked back, it was adopted in 1993, which was sometime after LUBA was created. And the ORS 197-800s are the statutes that deal with LUBA authority. So it creates LUBA, it tells LUBA what they can do, what their timelines are and all that. So that lives in the statutory provisions that created and deal with LUBA. So this statute is basically saying, LUBA, you need to give these local governments deference when they're interpreting their own code or comprehensive plan. So it's their own legislative provisions that they get to have deference on. It's not everything in the world. It's very common because pretty much every decision, overstating a little bit, but a lot of decisions involve interpretation of code. So it happens a lot. So 1993, this was adopted, and then everyone needed to figure out what exactly that meant. The first thing that came out was, well, one of the first things that came out in the cases after this was adopted was that the local government interpretation meant the boards or the city councils. It didn't mean hearings official. So this deference only applies to the electeds, so Board of Commissioners and City Council. So then there's, lines of cases about what exactly that was, and then, well, what does that mean for the planning commission or the hearings official, who are the non-electeds, don't get this deference. I did want to mention that this concept of deference wasn't made up by Oregon. The federal courts have a similar, or at least had a similar type of deference. It's called Chevron deference. We're kind of talking the same world. That was the federal version of deference, where federal courts had to defer to agency interpretations of their own rules and statutes. And the idea was that the agencies who adopted those rules were the experts in their field, and they were the ones who kind of knew. And that same policy applies here. It's that the Board of Commissioners, I'll just use the counties, Board of Commissioners knew what they meant when they were adopting code. So they're the ones who should have the say on what it means. So, yeah, as far as local governing bodies, so boards of commissions, when they're called to interpret a code, you turn to this statute, but when you read the statute, you're like, what the hell does that mean? Excuse me. So the case law explain what the statute means is an interpretation must be affirmed by LUBA as long as it is plausible. And that explanation of what the statute means is relatively recent. I think it's like 10 or 15 years ago. So it's kind of evolved and it's continuing to evolve. So for right now, the deference is LUBA must affirm it as long as it is plausible, which is pretty low bar. So as I said, the early case law said, we have this deference that the statute talks about, and then we have the hearings official. Hearings official interpretations, LUBA will affirm a hearings official interpretation if it is reasonable and correct. So you've got LUBA actually making the call of whether it's correct or not. So a lot more say LUBA has with regard to hearings official decisions. And then there's another caveat that Amber kind of mentioned is there's a little bit of a different rule when the code provision specifically implements a state law or a statewide planning goal or an OAR that implements the statewide planning goals. So the local government interpretation of their own provision that implements a state thing has to be consistent with that state law. So they have a little more sideboards there. So over the years, since this was adopted in 1993, after that, a lot of cities and counties went back and did what you're doing now. And they were like, oh, we get deference. We got to have everything go to our electeds because that's the only way we're going to get deference. So there was this push with both cities and counties to basically figure out how they could get through this process, given the tight timelines, and have it end up with the final decision by the electeds. So from 1993 to now, there's kind of been an up and down. I mean, a lot of the counties initially said, okay, we want our electeds to hear everything. And then I think that probably a lot of counties realized that it wasn't feasible for them to hear every single. So there's been a lot of back and forth as the counties have tried to figure out, we want to get deference, but can we hear every single one, and how do we do that? So having exactly the conversation you guys are having right now. And I looked through, there's LUBA creates head notes, which are kind of little blurbs of what each case stands for. And I wanted to give you an example of a situation where LUBA said, the elected made the interpretation, but we don't think it's plausible. To give you kind of an idea of how far along that has to be. And I happened to come up with one that is this issue that's near and dear to your heart, something that you guys talked about for a long time yesterday. And I don't mean to like put any kind of substantive film on this. So I'm just gonna I'm gonna read what the summary was that I created from.
It's not something we need to ex parte with.
Yeah, this is
Just checking. If I need to, I was
just.
gonna write it down.
I'm going to.
It involves the Goal 5 big game habitat. So it involves Crook County. It was a 2019 case, so relatively recent. Definitely in the time when we were talking about is it plausible or not. So the county comprehensive plan in Crook County contained a residential density standard for purposes of protecting big game habitat. A comprehensive plan policy limited residential density in protected deer winter range to 1 dwelling unit per 160 acres. And the county commission interpreted that policy to require that only non-farm dwellings be counted toward the density calculation. So you can think about what the density calculation, you guys are familiar with that density calculation, what that is intended to do. So LUBA struck down the county's, this is the Board of Commissioners interpretation, holding that there was no textual support in the density standard to only count non-farm dwellings, and that the comprehensive plan policies that the density limit was adopted to implement did not support distinguishing between farm and non-farm dwellings for purposes of computing density. So that's kind of a pretty good example of like, it has to make sense. So they said that was not a plausible interpretation. That's about it. If you have any questions, we just felt like you needed to have kind of that stepping back and like, when does interpretation apply and what are we talking about? So if there are any questions, Amber and I would be happy to try to answer them.
So I guess if you don't mind, Ann, the plausible part of that, what would have been a plausible interpretation of that for the contrast, maybe in my mind?
Well, I think that how I view it is the dwellings are, you're looking at how many dwellings because they're impacting the range. The animals move around through space, and to say that one dwelling, that's a certain type of dwelling, doesn't have that impact, didn't make any sense to them. So I don't know, obviously I think a reasonable interpretation is you're gonna count every dwelling in that density count, because each dwelling is gonna impact the deer range. So there wasn't really a rationale that could be provided by the Board of Commissioners of why they chose to pick just the non-farm dwellings and not the farm dwellings as well. So.
And I'm so glad you're here, by the way. Let me say that out loud. And one thing that we have to bear in mind in Oregon is that there are 36 counties. 2 of them are Multnomah and Washington. 2 of them are Marion and Lane. And the rest of them are kind of sparse. Crook County's smaller than Lane County, but it's got about this many people. So, but all of these decisions have to apply statewide. However, it's when it becomes highly localized based upon local conditions, which varies a little bit from Malheur to Multnomah.
Mhm.
So, you know, and that's what we have to bear in mind is that Lane County is different than Douglas County, than Marion County, Ben Lynn, or any other county.
Yeah, counties are different in size, they're different in, you know, all sorts of different things, and so you see in Amber's examples kind of all over the place as far as, you know, where they land on whether the board wants to hear something or not. And it's, you know, it's a local decision.
And if I may, one thing that I look for, and my question regarding which counties were they globally, is what is the nature of the counties that adopt certain types of rules? What are the local conditions that make their boards historically go in a certain direction?
Mhm.
Well, clearly, Washington and Multnomah County are very, very different to any other county, even different to Clackamas County, which touches them, you know. So bearing in mind that when we're making decisions for a county that is the largest coastal county. How about that? We don't even think of ourselves as a coastal county too much, but we're the largest coastal county. We're also the largest county that touches the peak of the Cascades. We're that. So we're different. We're the only county in some cases, in my mind. So
to that, as a follow-up, to what extent does LUBA consider or needs to consider the contextual differences county to county versus
Not those kinds of issues, they don't care about that.
Right.
They're just looking at what's the code say, what's the interpretation, right?
So to LUBA, dwelling versus farm dwelling versus non-farm doesn't matter what county it's in, or
No,
acreage versus not size
Yeah.
for habitat doesn't matter
Yeah.
what county it's in.
It does matter though what the county decides to adopt as findings supporting it. So if, you know, Crook County had come up with some, I don't know what it would be, but the findings make a difference, you know,
Can
especially
you-
with deference.
Yeah, and maybe you're gonna get to this. Can you just, I think it would be helpful, definitions of what is a finding versus what is evidence versus what is an argument?
Right now. you want-
Or maybe, is that a whole other work session? Is that an assignment for later?
Monty Python has a skit on
Right.
that.
The findings are the explanation of the rationale. The evidence are the facts that you're looking at. And the argument is arguing about how the facts apply to the certain criteria. that
Can
are-
you say that again about the findings? Sorry.
The findings are the kind of the written explanation,
Mhm.
providing the rationale for the decision.
Thank you.
And the decision generally has to look at all of the different approval criteria. And so you take an approval criteria and you take any of the relevant facts that apply to that approval criteria and you adopt these findings, which is the rationale explanation of how the facts and the approval criteria end up in either satisfying the criteria or not.
Thanks for that question, Chair, and thanks for that answer.
And Commissioner Farley, to circle back to your earlier question about which appeals can be appealed to of those 10 counties to the board, their boards, Clatsop, Lynn, and Tillamook
Clatsop,
are
Lynn,
the
and Tillamook.
three I believe we identified in that.
3 counties I always group together. Clatsop and Tillamook, yeah.
Any other questions at this point?
Yeah. Thank you for your expertise. I was just kind of sitting here thinking, if only we had a previous HO here, maybe you don't want to answer this in this setting, but would you, if I was a hearings official, I would want the input from the board to know these decisions and to weigh in. And I feel like that would take the pressure off the hearings official if there was a clear line. Am I correct in that line
I
of
can see
thinking?
that. I mean, there's so many different things playing into it, such as the tight timeline. So yeah, in an ideal world, if we didn't have that 150-day deadline, which that's not, I mean, it's been around for a while, but it wasn't always there.
Mm.
So in that situation, you know, you could see a scenario where the hearings official gets a decision and he's looking at this interpretation. And it'd be great to know what the board was thinking when they adopted this. Let me send that issue up. And I think that happened a lot more before we had these timeframes. And then send it back down to the hearings official to apply that interpretation. But it's just not as feasible as it used to be.
It's, yeah, in a perfect world though.
Yeah.
Yeah. Appreciate that.
If I may have a follow-up to that, all counties have a single hearings official, is that correct? No,
No,
help me with that. then.
not I mean, I don't, you guys, you probably know more from your state, but not every county or city has a hearings official. So
Okay.
when they're adopting their code, which is the chapter 14 is the appeal process and the processing applications, the county again gets to decide for themselves whether they want to use a hearings officer or whether they want to use the planning commission or what. A lot of places, especially the, larger, I think employ hearings officers just because they need another body to do all the applications.
And either one is statutory. Either one can be utilized by the county under a statutory law.
Hearings officials are mentioned in the state law, but they don't have the sideboards as much as others.
And
'Cause
hearings
it's
official-
more local law that creates the hearings officer's authority.
So we're fortunate in our size that we are able to have a hearings official because a hearings official bears a great deal of burden.
Well, we're in Lane County, so we have Land Watch and we have applicant attorneys who know this world inside and out. So there's a lot of cases here compared to number of cases in other counties.
And the complexity is tremendous, as we noticed yesterday.
Yeah, it is.
Can be. So then my last question on that is that the counties that do employ a hearings official, and I'm reading here where the hearings official decision is in certain cases final. This is one person who is kind of arbitrarily chosen, based upon merit, no question about that. But there's one person making a final decision for the entire county, and not an elected person at
Right.
that. Okay.
Yeah, some places have, I think partly because of that, have a lot more going to the planning commission.
Mhm. Which is also statutory, but it's not binding decisions that the planning commission makes, but unless it's specified.
Well, so the planning commission here mainly makes recommendations, but in some places, I think, planning commissions act kind of like the hearings officer acts here,
Yeah.
where they're making decisions that are final decisions that can be appealed, as opposed to here where the planning commission is just making recommendations to the board usually on most legislative matters.
That, you're helping clarify things that are kind of vague because of the differences between all the counties.
Yeah, well, it's hard to, unless you dig into it, it's hard to know why things are a certain way. Is that a certain way because the statute allows it, or is that a certain way because the board some time ago decided it to be that way?
Mhm.
So, and it's important sometimes to know that, especially when you're looking at changing what's written.
Yeah, and then occasionally the Supreme Court weighs in and says there's no more Chevron difference. So, okay.
Okay, so
Lots of deference.
Fascinating. Well, then there's another definition of deference that's in the dictionary, and that giving deference to a certain person. That's not the deference we're talking about here, but we defer as a board. We put a great deal of faith and trust in the hearings official to make the decisions that we can abide by,
Right.
and that really are consistent with what it is that we as a board, or the next board, or the last board, wants as a board.
okay, so options. And when we went over the same options at the last work session. So again, there's a variety of options that the board could consider. This is not meant to be an exhaustive list. So at the bottom here, we have others. There may be others out there that we're not aware of. But it's meant to provide an array of options to the board for consideration. And it's also not to advocate in any specific direction. If the board is interested in one or a combination of these options, we could dive more into possible code or policy amendments, or we could move forward with a project to work on a code policy amendment or procedure amendment rather. So the first option listed here is to revert back to the prior board review procedure. Just noting considerations with that are that it adds extensive time to the decision process. It's resource intensive for the various parties involved. Additionally, as I mentioned earlier, oftentimes decisions were affirmed and the board elected not to hold an on the record hearing. there were a number of work sessions leading up to the code change to discuss what the appropriate fee was, to right size that fee to have closer to cost recovery and consider the amount of appeals that the county receives. If we went back to the previous procedure, we would want to take a look at the fees again. Currently, there is no fee in place for the board review procedure. And as I mentioned earlier, there may be need for additional clarity of the criteria if the board wished to make them more clear and objective. And a benefit, of course, was that everything was coming before the board. The board could review the analysis and determine whether the board concurred with whether or not it met those criteria for on-the-record review and whether the board concurred with the hearing's official decision.
Question. Amber, I have a question. So you said it's time sensitive, and I'm looking at the case load that could potentially be if we were to revert back to the former elective review procedure. Are we talking that it adds a month? Does it add a year? What's typically, what in your opinion would be the average amount of time that would add to it that isn't already time consumptive enough for fighting it in the legal arena? I mean, is that comparatively the same?
Thanks for that question. Great question. So we estimated about a month before so the board packets are due in our office about a month before the board meeting. So under the previous procedure, staff would take, I want to say, an average of 5 plus hours to prepare the packets. Some are more complex, some are simpler, and then about a month of time at minimum to bring the item before the board.
So am I hearing you say that it delays the process by a month as far as the applicant's concerned?
Yeah, and it could be more because we're looking at logistics of scheduling and staff workloads. Sometimes it was more.
So worst case scenario, 3 months, 6 months, a year? What are we talking?
3 sounds a little long if I'm going from my institutional memory.
Sure.
I would say maybe 6-7 weeks.
So 2 months, let's call it, round it up. It would
2
delay it
months.
2 months in the applicant's view. Okay, so if I'm the applicant, I'm just kind of talking out loud here, just kind of like deciphering this in my head. If I'm the applicant and I've had an issue with trying to figure out if I'm gonna be able to build a permit something on my property and it delays it 2 months, but I get the board to hear it versus what we've experienced, some of these cases have been going on, what, 2-3 years? I mean, if I'm an applicant, I'm seeing that as a bargain. I don't know, am I missing something?
Thoughts on that? I mean, I certainly will mention that when there's a LUBA appeal and then it goes back to the hearings official, if there are issues that the board may have decided differently, then that could be additional time.
But would it extend into a year? I mean, we're talking 3 months, 2 months now, but would it be another 3 months? So in the applicant's mind, he's got 6 months in it? I mean, just for comparative sake, I'm in a project now I'm completing that's 3.2 years. And that's, when everything is in line and I didn't have to appeal anything. So, I mean, in my mind, I'm thinking as far as the applicant's concerned, this reverting to the elected procedure would be a win. And I just want to make sure I'm hearing all the information correctly.
I think there's a lot, it's a hard question to answer because there's a number of different variables in terms of, what specific issue is at play. And there have been instances, I can think of one appeal where there was an appeal where the hearings official addressed the incorrect criteria, and we were able to catch that in the elective review procedure, and then the board was able to make a decision on the correct criteria. I can imagine that would be an automatic remand had that gone up to LUBA and come back. So that would have added time had it gone up to LUBA, come back, and then the hearings official board would have reviewed the matter. In other cases, there could be an appeal inevitably. It's really hard to say. Do you have anything to add to that?
Yeah, no, that's pretty much, I think that's, yeah. I mean, I do think that the timeline is kind of what, the timeline was designed to protect applicants because applicant they need to get something done. for, you know, financial reasons or whatever. It sometimes goes against the applicant because, you know, they would maybe want to have that extra look by the board and it's, you know, takes time, you know, it puts a lot of pressure on all the parties. It's not an answer to anything, but sometimes some of the pressures that are playing at the initial decision stage.
Thank you. Commissioner Buck had a question, then Commissioner Farr.
All these questions and discussions mimic what we had when we were going through this a few years back and changed it to this particular method. Like, I just remember all the same conversations that we're having now. And I think part of the deliberation at the time was that in the majority of the cases, they were going to be appealed no matter what we made as a decision on the board when it came to us. And for a good chunk of those people, that was an extended delay that didn't make financial sense. And in addition to that, we have a division that has financial strain. And even though we reviewed the fees, it still didn't cover all the work that was required. And then you had to consider the work that they're not actually getting done because they're spending it on these appeals and coming to us and preparing all that work, knowing that we get a lot in Lane County. And so you also then have to consider, okay, are we going to extend times on Wednesdays where we're all here and we're going to be hearing these? Because you look at our regular agendas, you know, we're typically pretty packed on Tuesdays. So how much additional time do we as a board want to spend reviewing these each week or each month, however often they come through, and all the time in consideration of our staff that's sitting in front of us, preparing all that and going through it, and the expense, knowing that the majority of these would just be appealed up to LUBA no matter what. So when we came up with the criteria for them to come back to us, it was under a, you know, give and take of, there are certainly going to be ones that make sense for us to hear, and we're going to want to have the actual deference that Ann's talking about. But a lot of them don't reach that level. And can we save time and expense not only for the applicant, but also time and expense for us at the county going through that. And so there's just a balance that we're trying to, you know, make here. And so if there's a desire to increase the amount of those that are coming to us at the board, I would just caution that we need to determine how much time and effort we want to have on our regular agendas for that, given our workloads, but also that of our staff. And is it really going to benefit each and every applicant to be elevated to us? Or at what point is it a benefit, and what point is it just extra work?
And Commissioner Buck has a pretty clear recollection of that. And that is a discussion that was had. That does not make it not an appropriate discussion to have again at this point in time, because some of the things that Commissioner Buck stated are really absolutely correct. And what Council Davies said is that timeline was designed to protect the applicant. I put quotation marks around that. She just said that. And really, that really is what it's all about. And if it's a deterrent, if it's an encumbrance time-wise for the applicant, then it's not something that's the right thing. But what you're asking about, Commissioner, is what is the extended timeline, the legal process, and can the board review shorten that timeline? And that's a question that we have. And I think the board simply does not. There aren't enough hours in the day, days in the week, or weeks in the year to for the board to see everything. You know, I mean, that is impossible. So how can we weigh in on the things that our customers, the people we serve, feel are the most important to weigh in on? Not weighing in on everything, but on the things that they feel is the most important to weigh on. And how do we determine what those are? And to me, this is a board. 2 years ago, it was a different board. 4 years before that, it was a different board. And 2 years from now, it may be a different board. You know, so what we'd like to find is something that's going to be consistent, that different boards don't have to say, well, we don't quite think that same way, that we can do it the same way 10 years from now, as close as possible to the way we're doing it today. And that's one goal that I have. And but going back to what you said, Anne, is that the timeline was designed to protect the applicant. I love that. I think that we should write that on the wall. Skip timeline. This is all designed to protect the applicant. And that's really what it should be all about.
A question just to remind and ground us back. This is applicable only to land use around goal 5. Like, what is the scope? What are we talking about? What's the range of what this is going to potentially impact?
Any type 2 or 3 application. So those are the administrative applications made at the planning director level, like a forest template dwelling or a home occupation or a temporary medical hardship, or a flood flood-proof variance. And a type 3 would be like a telecommunication tower, zone change, temporary use permit, something that's more complex.
In unincorporated Lynn County.
Yes, outside of urban growth boundaries.
Did that answer your question, Chair?
Mhm.
Okay, because I thought I heard a number.
It answered my question. Yeah.
Okay.
Yeah, and so to Commissioner Buck's point, it's weighing that, right? Because if I read back what Ms. Davey said earlier, LUBA has to affirm what a board's interpretation, right?
If it's possible.
If it's plausible, yeah, I got that.
Which is a low
quotation.
bar, you said, yeah.
So I guess what cases are we going to make an interpretation on that might change LUBA's? You know, I mean, how do you predict that? How do you?
Yeah, it comes up during the argument. I mean, during the proceedings, there'll be arguments about either the facts or an interpretation. And if an interpretation gets raised by either side, or the planning director makes an interpretation in issuing their initial decision, then there's going to be an interpretation involved.
So the board's ruling does carry a lot of weight with LUBA's decision.
Yeah.
That didn't help.
And so I have a question that's sort of related, and also I just want to do a time check to make sure we get through because we have another item. Does LUBA take into consideration how do I want to ask this? The sort of training or qualifications of whatever body is hearing an opinion or an application in relation to the sort of veracity of the ruling?
No. What do you?
Well, I mean, sort of as to Commissioner Farr's point, boards come and go.
Yeah.
But the law is the law, and the training and the ability to filter a complex land use application through all those criteria at a hearings official or a professionally trained staff level who is really there to do a job that might be different than considerations or influences of an elected official. Is any of that a part of the LUBA conversation, or are they really just trying to strip everything away and be sort of, this is the law, this is your finding based on this evidence, and you're making this argument to support it, and we do or don't think that holds, and it doesn't matter who made that case. Thank you.
So a few more options to consider. So we considered whether there's an option available for parties to file for board review as an optional step, but there's a potential legal issue that comes up there that if administrative remedies, appeal steps haven't been exhausted, so if there's an optional step that someone doesn't follow the optional step, then that might invite a remand from LUBA potentially. There might be an option to have a process where a party can file an appeal to the board, kind of similar to the prior process, but potentially with new criteria or procedures. That would ensure the board has the option for review. I will just note with that only the applicant has the ability to waive timelines, to provide a timeline extension or waiver, and the county can't compel a timeline extension or waiver from the applicant. And it does bring up kind of the same level or same questions about resources as the prior procedure. There's the option of having some sort of call-up procedure, that those options that I mentioned. A couple of considerations with that. The main one is the 12-day appeal period. So those jurisdictions they call up procedures within 12 days of the ones where they are bringing items before the board and the board is making that determination. So in conversations with other counties and looking at our own code, that does provide a bit of a time constraint for staff to bring items before the board. But that certainly would ensure that decisions are coming before the board. And then there's also a question of which decisions. Is it all decisions? Is it certain types of decisions? Is it certain procedure types?
I have a question about timeline, and this is sort of hypothetical, but not really theoretical. For example, we're meeting 5 Tuesdays in October, but then we only have 2 meetings each in November and December. So bad luck of the draw as things are going, like to this point of there's at least a month's worth of work to prepare the board packet, and then there's the logistics of scheduling. Somebody could get caught in a situation where it could be quite protracted to add this. What is our obligation to meet a certain timeline? And how do we balance that with the many, many other initiatives and work of the county that we are overseeing besides the one very specific piece of land use?
Yes.
And how could we get ourselves in trouble because we simply could not fit it on the calendar within the timeline?
Yeah, so I'll skip ahead a little bit. So we do have mandated timelines for type 2 and 3 procedures. It's 150 days in rural areas outside of urban growth boundaries. In urban growth boundaries, it's less, it's 120 days. And then there's some other deadlines for telecommunication applications, depending on the kind of telecommunication request. But by and large, a lot of times we're looking at the 150-day clock. And if we don't meet that, then there's risk of the county needing to refund appeal fees, or excuse me, can't apply to appeal fees, but application fees, potentially appeal fees. And then there's also a risk of writ of mandamus, where the county loses jurisdiction over the application and the application goes to circuit court, and those can be very costly. So those are the risks with not meeting timelines. And I'll say that the previous procedure had that language in it saying that for the board to consider the matter, that timelines would need to be met. But practically speaking, an appellant could file an appeal. It went through the process. It's just that an on the record hearing would not be held if timelines could not be met. So it would be added to the timeline.
Thank you.
So you're saying that there could be an instance where the applicant could have a waiver of that and we could maybe circumvent that timeline? Is that what I'm hearing that you said?
Yes, the applicant has the option of providing a timeline extension up to 215 days over that 150 days. And then in some instances, waivers are allowed.
So 215 plus 150? So we're talking a year, basically. Okay.
So potential other options are the hearing's official decision as a final decision. Again, our code has a little bit of stuff about beyond that. The Also, there's the option of refining the current criteria, and or elevating more decisions under the current procedure. The criteria could be refined to be more clear and objective. The board could provide direction to staff to elevate more specific matters or specific issues. If that is the board's direction, we would recommend that that direction be added into the code, because that could provide guidance over time. It would memorialize things, it would make it clear to all parties. And also just help to minimize potential quasi-judicial risks that might come with not having that codified. And then there's also the option of having an application for a local code interpretation. So that's something that some other counties have, or to have an appeal allowance for a code interpretation. And that could be a standalone application. There's a county that has that go to their hearings official and then their board on appeal. And an advantage of that is that because it's not for the proposed development of land, it's an interpretation of a policy, then the timelines don't apply to that procedure, is our understanding. And then it also, it would add an extra application and cost. So that's a downside to that option. And a potential benefit is that it avoids appeals on a particular application where there's other criteria or facts involved. So it just really hones in on that one interpretation. Someone could apply for that ahead of applying for their application. So pros and cons to that. And then there's the option of having an appeal for those higher level, more conditional reviews, like the type 3 applications. And then I'll note, staff would recommend limiting the number of requests for reconsideration, because currently they are unlimited before the hearings official. So that does create additional appeal steps. So that's something we could take a look at as well. And then considerations, and we've talked about a lot of these, so I'll try to summarize quickly. So just considerations for the board as you're thinking about options are time efficiency, the deadlines for appeal, meaning that in that call-up procedure that there's that 12-day quick sort of turnaround to elevate matters. Timeline mandates, we just talked about that. County resources. There can be costs incurred to the county and the parties involved associated with needing to bring out consultants or attorneys for additional appeals. Talked about deference, of course, quasi-judicial procedural requirements. The remand procedures depend on the decision maker and the current code. So that's one thing to consider, is if the board is the decision maker, then the remand procedures would specify that LUBA remand would come to the board currently. And then wanted to highlight again that if we make a procedural change, we're likely that will require an amendment to Lane Code Chapter 14. And code amendments they can take upwards of a year or more. The last amendments to Chapter 14 took about 5 years. Partially because of appeals, code amendments can be appealed, and the last update of Chapter 14, which was more of an overhaul of Chapter 14, more of a substantive, comprehensive update, but there were 2 appeals to LUBA of that ordinance. And the last thing I'll note, just kind of on some last considerations, is I'll just remind the board of we have a couple of pretty significant projects that are mandated by state law or federal law, one of which you'll hear about in a few minutes, regarding FEMA's preliminary PICMs, the preliminary implementation compliance measures for the BIOP. And we also have House Bill 3197, which is the requirements, which are we're working on that project. It's underway, to adopt more clear and objective standards. We have a pretty tight timeframe of July 1st, 2025. We have brought a consultant on board to help with that work. But just two pretty significant projects that are state and federally required. I'll also note that if the board provides direction, an option, we always try to take a look at with code amendments is having a public engagement process. So we could pull together some consultants, attorneys who are really familiar with our process, who are frequently filing applications, and ask for their input, and see if they have any recommendations for how the process, how they'd like to see the process work.
Commissioner Forrest.
Can you elaborate a little bit on the value of that?
It's highly, highly valuable because they are the ones filing appeals, and they see things that and this is just general for public engagement. I think public engagement, we're looking at the stakeholders, the users of the code. They're the ones most impacted. So we would, particularly with a large procedural change, we would want to gather input to see what we missed and
boots on the ground. Is there a chance of bias, or fear of bias when you ask for that kind of input?
looking at Anne.
I mean, so public involvement is basically an opportunity for anyone and everyone. And so if it's the applicant attorneys who come in because they want to change the process, then you consider that. As long as you can make a neutral decision based on everything before you, then I don't think there's an issue with bias.
This is kind of like having dinner with a doctor having animal.
I know, right? It's molar right here, yeah.
And what if, oh, sorry. if I-
No, you go ahead.
Well, just what if any, in such a thing, which, I mean, I always think we are a public entity and we're here to serve the public. So we should always be engaging and involving the public in a way that informs our ultimate work so that it's reflective and responsive and defensible to the public, because we involve the public. So I'm all for that. What is the role or opportunity for our planning commission to, where do they fit in something like that? Were we to do something, a process
Yeah,
like that?
so in addition to their citizen involvement committee, so they are serving in that role of soliciting public input in their processes and our processes. And they would review draft code and make a recommendation to the board. And also I just want to clarify a little bit. I think I said applicants, attorneys, consultants, but we would also include any party who's working with this process frequently. And
That's kind of what I heard.
Great.
Yeah.
Yeah, I guess I asked that also just to point out, I mean, our committees are part of our capacity if we use them well. And so that's
And
an
a code
opportunity.
amendment is required to go to the planning commission in any.
Right, but that's, somebody else made it and then they respond to it, as opposed to they are also part of that process of developing it.
Yeah.
Right. Vice Chair Hannah.
Yeah, I mean, just forgive the crassness of how I look at this, but that sounds to me like free help. I mean, if we're constrained with staff time and big projects like you said, Amber, coming up, it seems to me like if we, as a board, gave some sort of a board directive to have the planning commission solicit input from applicants, attorneys, consultants, parties to give us suggestions to change codes or procedures. I think that would be a great start, and it wouldn't really involve all of our staff to be tied up. And I think that might move the needle a little more efficiently and maybe quicker in just the next few months. Thoughts?
Well, I'm sure Amber probably has a response, but I just want to say, it takes staff time to prepare for those meetings, manage those meetings, facilitate those meetings, compile the feedback from those meetings. It actually adds staff time, but it's also adds value that makes it worth adding the staff.
Very
time.
directed staff time, you know.
But comparatively speaking, is it less than if we said, oh, we want to change a bunch of codes and you guys had to add that to your workload? I mean, I'm just kind of balancing the two evils here.
I think it's part of the process to go to the planning commission, and their role and their input is invaluable, and they can certainly help to facilitate. So they would hold work sessions with staff, and staff would prepare for those and present code. They usually aren't the ones to go out and hold or solicit preemptive public engagement, meaning that as we're leading up to draft code and those work sessions, we have gone around to different areas of the county and met with different groups for the floodplain code. I believe Rachel did that. And we can solicit comment on draft code earlier in the process. That would be staff leading that work. And then when we go to the planning commission, certainly they would be the ones holding work sessions and public hearings, and the public can come testify at the public hearings, and they're vital to that role of hearing the input and then deliberating on it and making an informed recommendation to the board based on what they've heard from the public. That answer your question, Commissioner?
No, not really, but
Well,
thanks for trying. I mean,
I'll just throw in, it's staff, it's heavy staff time to do that. It's not gonna make it easier on staff.
Okay,
Staff's
well-
gonna have to spend a lot of time doing that, so citizen involvement piece.
Do you mean the planning commission also has day jobs?
well, okay, I'm just trying to digest in my mind what it is we're gonna do. I mean, to do nothing, I think is not an option in my mind. So I'm thinking we owe ourselves some degree of direction so that the people who are coming from us, applicants who we've seen and have a lot of issues going on, that we can at least attempt to do something to help mitigate that. So I'm struggling as if maybe I could use your input or Council Ann's input here, if we could come up with some sort of thing that we could do to help the process, or at least suggest shine some light on this rather than just do nothing. I think that's where I'm at. So I'm trying to decide the balance. What I'm hearing you say is there's a lot of issues going on. There's a lot of subject matters that are considerations for legal and timelines and all of that. And in my mind, I'm kind of sifting through all this thinking, okay, so if we had something that was compact and risk adverse and allowed the applicant to choose, okay, look, rather than do X, Y, or Z and have the opportunity of having to mandate to get an attorney and fight all this for a year's process, you pay an X number of fee, which it may be a higher fee than what we have in the system, but at least in their mind, that would be a worthy investment to save time or efficiency, or to at least get an answer without having to expend over the length of time. I mean, some of my people that I've contacted with have spent over $100,000 on these kinds of appeals. I can't imagine, like, even if we had a $5,000 fee, just throwing that number out there, that we had a procedure that said, okay, Mr. Applicant, if you don't agree with what's going on, you can appeal to the board. You have to waive a time deadline to where we get that scheduled as soon as we can. It could take up to 6 months. But in 6 months, you've spent $5,000 and you have an answer that is 98% there. I mean, and help me if I've got this all whacked.
Sorry, I stopped sharing screen, but I can go back to that list of options.
Right.
Commissioner Buck has a comment or question when you're ready, Amber.
Application for local code of policy interpretation.
I mean, can you go back to the slide that shows what our criteria for viewing applications are currently?
The current criteria.
Yeah. Because what I hear you're saying is, honestly, one of the options, which is to maybe provide more clarity under one of these 4 subjects as to which ones should come to the board for review. Especially, I think item number 1 up here, because that's very general.
Mhm.
And instead of reverting back and listening to a lot of them, which we know we don't have time or money to really do all that, but to really dig into maybe item number 1 here and determine and make it more clear so that the department knows exactly which ones we want to have come to the board to review. And that could be more than what we're hearing now, but it wouldn't be excessive. Where it's not efficient or time consuming or very expensive for the department.
I think our public works director, did
Yeah.
you want to come to the table, Dan, and offer something up?
Sure.
Thank
Along
you.
those lines, I was kind of thinking similarly, Commissioner Buck, that we have these criteria here. And I think one issue may be that this is more of a director push to the board. And if there could also be a pull in the other direction, if the board wanted to say, okay, I think it meets one of these criteria, could we consider bringing it to the board?
Mhm.
So there could be both directions, but they would still use the same criteria to try to evaluate whether that warrants going to the board. That's
But we would have to have some caveat there about timeline, because what I'm hearing is that there's a certain risk that if we don't do it in a certain time period, we're liable for something. So there has to be some sort of timeline waiver within that process is my thought.
Yeah, which is currently there for the planning director. Does that include a timeline?
It's part of the consideration, certainly.
Yeah.
And the-
Commissioner Farr, did you?
Directly along those lines, you know, a lot of this is applicant driven, and if you pop back to the options screen, one option is an application for local code of policy interpretation, which could be an application by the applicant that would allow for an interpretation, really short term or short timeline interpretation based on an application. And it's not just a general, we want to see all of these, it's the ones that the applicant specifically want to see. And then they can apply for an interpretation based on, back to the other screen, where am I here? The current procedure, number one, yeah.
Mhm.
Yeah, so that having that application as one of our options, utilizing that option would potentially cut a great deal of time off for the applicant. And for us and for them, you know, because it narrows it down to what applicants specifically want.
I mean, some of the criticisms I've heard is like, why can't the board hear my case? Why can't the board hear my case? And I heard that from one applicant, I bet you 8 months.
Mhm.
And, you know, he kept spending money and money and money. And it was like, okay, if there was some vehicle of which the applicant took, I guess, responsibility, for lack of better words, of timeline and paid a fee, I'm sure he would have gladly paid $5,000 versus the 30,000 he paid in that 8-month period to his attorney. I'm just kind of, you know, and to, you know, Chair's point about, you know, we have 5 meetings and then 2 in the next successive months. The timeline waiver would say, okay, we're going to get it in, and we're hoping to get it in a certain 6-month time frame. At least they would have a concrete procedure ahead of them rather than some nebulous thing they couldn't wrap their head around.
And I think they've given us an option there.
Yeah.
And the applicant would have to be willing to accommodate a longer time period.
Yes.
And if it would be up to them to take on that liability, because obviously more time costs people more money. But
Time is always money in building,
if
you're
they,
right.
yeah, I mean, it could be a combination between maybe item number 1 being clarified and a particular option for an extra application.
Yeah, absolutely, yeah.
And I'll mention, currently under the current regulations, if there was an interpretation request or just the nature of land use application, that there's an interpretation that comes up, and then the hearings official makes a decision on that, and then it's an interpretation of county policies or issues of countywide significance, then we can elevate that matter to the board under the current procedure. If the board would like to revise that interpretation of county policy language or those criteria, make it more specific or more encompassing, then that would require a code memo. We do have that option in the under the current system. A lot of times, Commissioner Lovell, your question about applicants wanting to know if they can appeal to the board, a lot of times the decisions are dealing with interpretations of deeds, of different criteria that might be in state law. There's a lot of different levels of interpretations that can happen, and so I think that's really the heart of the question for the board is, you know, what do you want to see to come before you?
Well, according to the Powell Man report, you know, most of that was legal lot verifications is what you're, I'm sure, adhering to or, you know, talking about there. Which is not something that the board is an elevated criteria, I mean, so.
Well, and that has a potential of elevating a lot of
every-
stuff
yeah,
to
that's
us.
a lot of cases.
So, you know, we have to be
67% of them.
diligent about which ones.
It sounds like, thank you so much, because I mean, the point of these work sessions, I think, is because people ask
Gotta wave-
questions.
wave this is-
The gallery. Hey, how come I never get to go out there?
Because people ask these questions, why can't the board hear or what? These work sessions are an opportunity to give us a little more information to answer that question or to understand when maybe we don't have the information and refer the question to staff for an explanation. So these sort of deep dive work sessions, at least for me, and it seems like from the conversation, are doing what they're designed to do, which is just to give us a little more grounding at a more detailed level of what is the process and where are the opportunities to make adaptations to it to make it more responsive to what the public needs. And that's different than responding one-off to particular circumstances. This is a systems, right? To understand the system better. And I'm always saying our job as commissioners is to zoom into the detail enough to understand it. So when we zoom out to make the decisions, bigger, broader, stand the test of time decisions, they're informed. And so this work session, I think, is really helpful to us to be able to do that, to get the history, because even if boards don't change, we get a lot of information in a week. So your job, and that's the beauty of having departments that specialize, is you hold on to much more detail and understand the nuance of it. That's your job. And also your job, like what you did so beautifully today, is to remind us and bring us to that level of grounding so we make better decisions. So thank you. I think this was really helpful and really informative and really good to also have in a public session so anybody can go watch this. To your question, Vice Chair, or others that get questions, why can't I? What is the process now? We've got something we can refer them to watch and listen to us wrestle with this. And so maybe there will be, after some percolating on this information and reviewing the materials, and different commissioners, I encourage folks always, staff is always so responsive and available to ask some follow-up questions and help shape thoughts or considerations if any one of us wants to bring something forward to make some changes to the process and understand what that would take. So this was great. I'm seeing people agreeing.
I think this has been one of the most informative work sessions we've
Yeah.
had, period.
Yeah.
And it's good to have a doctor in the house. Thank you.
So is there anything else you want to
Hurts my stomach.
you want to offer before we conclude this item and then move into the next one?
I don't think so. Just thank you so much for the time and discussion this morning.
Great, thank you.
Well, I have to add this, that any one-off to us is the only one, the applicant. So it may be one-off to us, but it's the one to them. So we have to be sensitive to that. all the time.
And any one applicant today may represent many in the future, we don't know, so making
Conditions.
those system decisions are really important for the
Of
future
course.
too. Thank you. So our next work session item is Richard Surslev, our senior planner, is going to come to the table. Welcome. And this is, what did you call the what did you call them? Pick'em. Did you bring your banjo? Pre-implementation measures. And this is for the integration of the Endangered Species Act in Oregon. And as soon as you have a minute to switch things over, are you doing a screen share also, Rachel? Okay. It looks like we're taking a 1 minute pause. I don't think we need Metro to pause. We are still live on Metro, but a couple of commissioners just need a minute to step out and step back in. And while we get the next presentation up, we are still live.
So Rachel, you need to just share that. So it's up on the desktop and you just need to kind of hover. I think so it's on the screen in your room, but it's not on the Zoom. So you just need to share that screen.
They're not, it's,
The buyout letter, did you see that email?
oh, it's on the desktop, sorry. Thank you.
It's The implementation compliance measures. Okay.
It is right there, on the screen. Oh, there it was. You didn't get donuts? What the heck? No food?
Real food?
That's the favorite part about being on here.
Okay. We are all assembled again, so whenever you're ready,
Okay,
Rachel, I'll have you
great.
introduce the item. Thanks for
Thank
being here.
you. Good morning, commissioners. I'm Rachel Surslow, senior planner, also a floodplain manager, which is relevant to this item. So I'm here before you today to discuss the pre-implementation compliance measures, or what FEMA is calling PICMs. And this is a project to implement the biological opinion for Oregon, which I will refer to as BIOP. And just as a note, there's going to be a lot of acronyms. I'll do my best to speak them out so we all know what we're talking about. But yeah, it's a complex issue. Yeah. So a summary, on July 15th of this year, FEMA issued a letter to National Flood Insurance Program communities, those are NFIP communities, regarding PICM requirements. And this is a letter, the letter that was issued outlined 3 interim options for complying with the Oregon BIOP. And my presentation today will go over those 3 options and talk about what that means for Lane County. And the other thing that the letter did was notified communities that FEMA will be delaying the processing of letter of map revisions and conditional letter of map revisions. Those are CLOMARs and LOMARs based on fill. And so they are going to delay the processing of those requests. It really doesn't have a lot of impact on Lane County's processing of floodplain permits, but we are putting customers on notice and letting people know that that's happening at FEMA's level. And so that's something else that was announced in that letter. And so moving into the history of the BIOP, there's a long history with this thing. So in 2009, a lawsuit was filed against FEMA, and the lawsuit, the basis of it was that FEMA should have consulted with the National Marine Fisheries Service, NMFS, and the National Oceanic Atmospheric Administration, or NOAA Fisheries, on how NFIP regulations are impacting endangered species. So that was the basis of the lawsuit, was that FEMA, you messed up by not consulting with these fishery services to figure out what the impact of regulations were on endangered species. As a result of that lawsuit, FEMA had to consult with those agencies, and as a result of that consultation, the BIOP was produced. It's a biological opinion specific for Oregon, and it outlines how the NFIP is impacting endangered species. Specifically, the BIOP found that the NFIP reduces quantity and quality of floodplain and in-channel habitat for 17 marine and dromonous species, and adversely adversely modifies critical habitat for 16 of those species. And so the BIOP also outlined reasonable and prudent alternatives, which were basically ways for FEMA to mitigate the impact to the endangered species. And so since implementing the BIOP, there was a delay in implementation of the BIOP from 2016 to 2019. Then in 2019 to 2021, FEMA did start work on their implementation of the BIOP. They're working on a draft implementation plan. And today or 2023 to today, the implementation plan is still going through the final approval process or the NEPA process. The National Environmental Policy Act, which any federal rulemaking needs to go through that NEPA process. So the results of the BIOP, this implementation plan is not final. And what's happening right now is an interim measure to implement some sort of avenue for protecting endangered species in the interim while they're working on finalizing the draft plan. So just talking a little bit more about how this affects Oregon. It affects most of Oregon, as you can see from this map. It's effective in 31 of 36 counties and affects all of the National Flood Insurance Program communities within those counties. As you can see, the BIOP plan area outlined in green encompasses all of Lane County. So that means that any code amendments or any implications of the BIOP will affect all of the special flood hazard area in Lane County. So whatever action that the board takes will have that effect on floodplain in Lane County. So moving into the PICM pathways. So like I said, in the letter that was issued in July, FEMA outlined 3 pathways that communities could take. And those 3 pathways are to adopt a model ordinance. So FEMA has issued a model ordinance that addresses what local communities can do to protect endangered species. So that is one option. The other option is doing a permit by permit review. So this wouldn't involve adopting specific standards into our code, but it would involve our department reviewing floodplain development permits, each floodplain development permit for its impact on habitat and floodplain functions and endangered species. And then the third option is to prohibit development in the floodplain entirely. And I'll go into each of these options. So starting with the model ordinance, the model ordinance focuses on no net loss, and actually all 3 of the options focus on no net loss. So what does that mean? Well, FEMA defines that as avoiding or offsetting adverse impacts of development occurring in the floodplain. And the floodplain function specifically that FEMA is trying to protect is floodplain storage, water quality, and vegetation. So the model ordinance specifically tries to meet this no net loss standard, and it does that by avoiding negative effects, first avoiding negative effects, then possibly minimizing any effects that exist, or replacing or compensating for any of those negative effects. So the negative effect being development in the floodplain. Basically, they're trying to offset or minimize the negative effects of having any sort of development, may it be a house or fill material or anything like that in the floodplain. So specifically the model ordinance focuses on retaining undeveloped space in the floodplain, which would address the floodplain storage function, minimizing the amount of impervious surfaces, which addresses water quality floodplain functions, and then retaining trees in the floodplain, which addresses the vegetation floodplain function. Also related to that is the model code includes stormwater regulations, which intend to mitigate that impervious surfaces that may be existing in the floodplain. And it also outlines a riparian buffer zone that obviously aims to retain vegetation. The model code also regulates the location and timing of those no net loss activities. So ensuring that it's happening on the same property or in the same waterway or watershed area, and then also happening at the same time of when the development is established. That compensation should be happening at the same time. So moving into the permit way, this is the second option, and it involves community reviewing development permits on an individual basis for the impact that the proposed development will have on floodplain habitat functions. So basically, we're still achieving the same no net loss. But it's happening by reviewing each individual permit, and there's not necessarily standards adopted into our code. And an applicant would, when they're filing their floodplain development permit, they would have to include some sort of habitat assessment or some sort of mitigation plan for their proposed development. There are some exceptions that FEMA has outlined, and FEMA has also created a habitat assessment and mitigation guide to assist local communities and customers in putting together these applications and submitting a habitat assessment.
Do you want questions as we go, or do you want to get through your presentation?
No, we can do questions.
Particularly given our previous item, from what little I'm understanding so far about this, if we have a code amendment, to whom would somebody appeal if they didn't like our interpretation of the impact on their particular application?
For the permit on permit
Mhm.
basis. I think
The FEMA.
it would be through a type 1 permit process, I believe, and I don't know if that could be appealed to the HO.
Are you asking about who would appeal the code that's adopted, or?
I'm saying fast forward, we adopted code, but it's open to interpretation. So if it's permit by permit, any individual person can say, I don't think you properly interpreted your own code as it applies to my application. So I
Yeah.
don't accept this ruling. Who made that ruling, and then what is that? Are we putting, is this potentially another pathway toward the situation we were just talking about in the previous item?
So it can go a couple of different ways. So if we did the model code process, the code could be appealed up to loop, like the adoption of the actual model ordinance could be appealed. If we're doing a permit by permit pathway, my understanding is that could still be done under a type 1 review, and then whatever appeal procedures are available for type 1 review, we would follow those, and it would probably go to the HO.
Yeah, if we kept the process the same as it is now, yeah.
Got it.
Well,
Just one point on that. So the chapter 14 procedures do not allow for appeal of a type 1 application or determination, provided there's no discretion in there. And I think when we would, if the direction was to adopt code to allow for the habitat by habitat assessment, for instance, we would want to take a look at that, try to make it clear and objective so that it's a type 1 determination, then it doesn't constitute a land use decision, and then there's no local appeal process for that.
Got it. Thank you. This chair has a question.
Yeah, I have a question, and this is maybe putting ahead of the game, sorry. What about some of these folks who have already got LOMRs, and projects in place? Does this affect them retroactively, or is there a certain cutoff point where we're gonna be able to have, and I'm thinking of Wildish off my top of my head, who's had a floodplain fill permit just south of Springfield for 9-10 years now, and they're 90% done, and their concern was that we put this in there, it may take the 200,000 units of whatever they put on that property to bring it out of the floodplain into jeopardy. So what do we do for those folks that already have projects in process that have already been pre-approved?
If they already have a LOMR, a letter of map revision or a letter of map amendment, that's an action where FEMA has formally amended the floodplain to say your project, your specific project or this specific area isn't in the floodplain. So if it's not in the floodplain, these standards are not going to apply to that situation because it's been removed.
Well, there's the caveat. If they're not completed yet, then formally that particular land has not been formally taken out of the floodplain. That's still in
So
process.
they haven't completed the LOMA.
Well, that's my question. I mean, do we have some protections for folks that are in process of complying with that? So they could be 9 years into it and we adopt this and all of a sudden they're hosed, so to speak.
Well, there are two different, I think there are two different avenues. So one is a letter of map amendment process in which FEMA is taking the action to remove
either a project or a piece of property from the floodplain. If that's not complete, then the project would still be in the floodplain and would have to comply with these codes.
Rachel, how long does that typically take? A Loma lower?
For FEMA to process it, I've heard up to 6 months. Yeah, but it can take some time in addition to that, having a surveyor and doing the work that's required before actually filing it to FEMA.
So would it be prudent for the board to put notices out to people at this point and say, hey, this is what's coming down the pike, or at least the board have some sort of some sort of timeline that we can at least honor those people that are in process by a certain date? Otherwise, I just don't want to have somebody like Wildest come to me and say,
Yeah.
we're totally screwed and we can't do anything about it. That's just not right.
So in regards to the LOMARs, like I said, FEMA's delaying their processing of LOMARs. We have been notifying applicants and customers of that action. It's, like I said, it's not impacting us issuing permits at this point, but say we issued a permit and someone's long-term plan was to go get a LOMA, they would get to FEMA and FEMA would say, no, we're not even processing those anymore. So in our permits, we're putting notice that says, hey, this is FEMA's delaying processing of these things. So you're aware that your long-term plans might not come to fruition. There will be, I can talk about where notice is going to come in to this project later. Yeah. Does that answer your question for now?
So far?
Okay.
Thanks.
So permit by permit, again, not adopting specific standards. We would have this guidance document created by FEMA for habitat assessment and mitigation plans. And an applicant would put together a habitat assessment and submit that with their floodplain permit. We would review it and say, yes, this looks like you're addressing all of the necessary things that you need to address for a habitat assessment, and you're not creating, we're finding no net loss with this assessment. This would still require a local code amendment to allow us to do this type of review within the type 1, within a floodplain permit. But it would be a lot less of an intensive code amendment to adopt this pathway than to adopt the model code pathway. The prohibition is the third pathway that FEMA advertises. It's pretty straightforward, prohibit all development in the regulatory floodplain. The implications of this is that Lane County has about 130,000 acres of mapped floodplain and approximately 13,000 properties that are either fully or partially within the floodplain. So a prohibition on development is going to have a significant impact on us as a community. Also, if we were going to prohibit development, that would have to be adopted in some way into our code. Lastly is taking no action. This is not an option that's advertised or encouraged by FEMA nor staff, but it is an option nonetheless. And the implications of such an action of not doing anything would be that we could be suspended from the National Flood Insurance Program. And the impact of suspension from the NFIP is that homeowners in Lane County would no longer have access to discounted flood insurance and affordable flood insurance policies. And Lane County would not be eligible for certain disaster relief funding. And then and currently there are about 1,600 national flood insurance policies in Lane County, representing approximately $423 million in coverage.
Commissioner Parr.
Thank you. Something I've been meaning to ask for a long time. What is the dollar value of that discount for a homeowners?
I don't know.
Is it $10,000 a year, or is it a few dollars a year?
Yeah, I don't know the dollar value of the discount. It's a 20% discount on their premium. So
just the flood insurance portion of their premium.
Yeah.
It's not a big amount of money. Okay. All right. It's a small amount of money for the average homeowner.
My memory is all of a sudden going crazy here. Didn't we, as a board, about 6 months or a year ago, maybe vote that we were increasing the floodplain an inch or so that we could get a higher discount, so therefore we brought more properties into the floodplain that are now gonna require insurance? Wasn't that not what I asked a question on at one meeting, I remember?
We did not bring more properties into the floodplain. We increased the discount. So by participating in the community rating system, which is a subset of the National Flood Insurance Program, we used to have a discount on flood insurance premiums of 15%. And by adopting a higher regulatory standard that you're referencing in the code amendments that were brought before you a couple of years ago, by adopting those higher regulatory standards, we've increased our discount from 15% to 20%. So homeowners with a flood insurance policy in Lane County are getting a greater discount because of the additional protections that we've adopted for floodplain development.
But those additional protections weren't increasing the floodplain as an area. Okay, that was my question. Thank you.
And it goes back to I want to know what it means to the average homeowner in terms of the check that I write, because I buy it. You know, I buy floodplain insurance. How much would I save? What is that 20%? And I understand if you don't have an answer to that, but it's something I'd like to have the answer to, just in the back of my mind.
Yeah.
So I say we're increasing regulations on floodplain to get you a discount, and you're gonna save $22 a year.
I can definitely get in touch with our CRS specialists and see if they can give me just like an average number.
And I could sure look at mine, but I'm really on the edge of the floodplain.
Commissioner Buckman, question.
I understand your question, Commissioner, on how much they're saving, but I think it has a ripple effect. You know, it's not just their premium and a discount on the premium, but if they don't have this insurance, sometimes they can't get a mortgage or homeowners insurance if they don't have
I understand that.
this one. But I'm most concerned, not only am I concerned about that, but I'm really the most concerned about not being eligible for disaster relief funding. I think that should give us pause.
And that's something that we need to explore a little bit further, is what is the possibility of not being eligible for disaster relief funding if in fact I don't get a discount on my floodplain insurance.
That's something I would probably have to consult with our emergency
And
management.
please don't feel an
division.
obligation to answer that in the near future, but it's something that is a question that would come up if we're increasing regulations, which we're gonna consider doing. What does it mean to me as the average homeowner in the floodplain in Lane County?
Commissioner Seneca has a question or comment?
Yeah. And so we raised the FEMA flood maps vertically, not horizontally, right?
Not necessarily.
Oh, not necessarily.
So we didn't change any of the technical flood mapping. So we didn't increase the area of the floodplain, and we didn't say that it's going to flood at a higher level. What we did do is our higher regulatory standards require, say, a house in the flood being built in the floodplain. The first floor of the house needs to be built to a higher level than it used to have to be.
Right. Yeah. Okay.
Just wanted to make,
Yeah, no, I appreciate it.
really
Yep.
nuanced, but yeah, just wanted to
No.
make sure.
Much more detail. Yes, I appreciate it. So now with FEMA holding those WOMRs back,
Mhm.
delaying those, we've in effect slowed possible building, right? In those because they if they were going to build in those, they would have to raise it up a couple of inches, is what we were told during that presentation. And now they're holding back those permits. What's the outcome on that?
Typically, a property owner would be getting their letter of map amendment after they've built their structure. So they would come to us and get a floodplain permit. They would do all their permitting. They would go build their house to whatever higher level they want. And then they go to FEMA and they say, hey, FEMA, I built my house to this level. I'm no longer in the floodplain. I should be exempt from floodplain regulations and I should not have to get flood insurance. And FEMA is not processing those requests any longer.
Okay, got it. I thought that order was reversed. Thank you.
Okay, so I think I covered everything with taking no action. Not an ideal option, but an option nonetheless. So I just want to talk a bit about the Pickham timeline. As I mentioned initially, we got notice of this action from FEMA on July 15th, 2024. At the time of that letter, we didn't receive any resources from FEMA, so we didn't have a draft model code and we didn't have the habitat assessment and mitigation guide. Those things were published on August 14th, about a month after we got the letter. And looking forward a little bit in October, this month and next month, FEMA is planning to hold workshops with NFIP communities to assist them in what it's going to look like to implement the model code and the habitat assessment guide. So at this point, I personally and many jurisdictions in the county haven't conversed with FEMA or haven't gotten assistance from FEMA on actually implementing these things. We only have these resources, and what we know about them is, you know, the reading I've done of them and the research I've done of them at this point. So we do plan on participating in those workshops in the coming months to get more information about what the implication of these things are. And then the most important deadline that we have here is December 1st of 2024. Communities must select and implement one of the PICMs. And there's been a little bit of confusion about this, what has to happen on this date. In the letter that we were issued, we for sure need to tell FEMA what we're choosing by December 1st. In some coordination meetings that I've been on with FEMA, they've also indicated that we need to be implementing one of the options by December 1st. And then also in the letter that we've received, if we do not indicate what PICM we're choosing by December 1st, we're going to default to the permit by permit basis. Where I think the confusion is occurring is that FEMA doesn't realize that Oregon has a pretty intense legislative code amendment process. So even if we defaulted to the permit by permit basis, we still need to do a code amendment to allow that. And I think FEMA didn't anticipate that. They were understanding that, oh, we would default to the permit by permit and that could be implemented immediately. But I don't believe that that's the case, and we would have to do some sort of code amendment.
That's where the governor's letter is.
Exactly.
Right.
It's
Another opportunity to
Yeah,
appreciate our governor understanding.
I'm gonna get to that in just a moment. And I will talk about that. So then looking forward, FEMA in this letter outlines some requirements for reporting. So starting January 31st of next year, we'll have to start reporting on our PICM implementation. And by July 31st of 2025, we have to fully implement the PICM. And then looking even more forward in 2027 is when the actual full implementation of the BIOP is planned to occur. So instead of these 3 interim measures, they're planning in 2027 to have everything fully implemented. And I just quickly wanted to go through, since we have this timeline, deadline of December 1st, 2024, which we're not going to be able to meet if we have to go through a code amendment process. I did just want to touch on what all goes into a code amendment process. We're hoping to get direction from the board, maybe not today, but at some point on what PICM we're going to move forward with. And after we have that direction, staff would draft code reflecting the PICM decision, and then we would need to send a ballot measure 56 notice to all properties in the floodplain. And that's going to generate obviously a lot of public comment, especially given the content of the action being taken. And then we'll be moving into planning commission public hearings and board public hearings before we adopt an actual code. So that's kind of the process that we're looking at, and the process that FEMA would like us to go through before December 1st, 2024.
right on.
Yeah.
Sorry, where's our sentiment?
I think I will just quote our administrator. It's nice to want things.
Okay, just out of curiosity, what is that normal process timeline? I mean, in a perfect world.
I would an FJ.
Probably a year, 6 months to a year for a normal code amendment process.
Yeah. Okay,
I would say.
that's what I thought it was.
Feasible by December 1.
Yeah.
Not feasible by December. Okay, I just want to make sure I'm
Yeah.
understanding that. Good.
And
Thank
the
you.
governor agrees, so.
Yeah, good. Got some people on our team.
So just a few other things, including the governor's letter. So I just want to point out that there are other a lot of other jurisdictions and counties are dealing with this, and Lane County is not alone in trying to figure out how to move forward. I just want to mention a couple of counties that have decided what they're doing. Deschutes and Wasco County have chosen the model code pathway. And then another unique thing that we found was that Clatsop County hasn't chosen a pathway, but they're implementing a temporary moratorium on issuing floodplain development permits until I think they decide on a pick'em or are able to enforce one of the pick'ems.
Do we know, has the AOC taken a position, or can we do some organizing through the AOC on this, if you know?
They're holding bi-weekly meetings, is that correct?
Someone is holding, I don't know if it's the AOC.
I'm not seeing either.
That's holding them.
We've been sitting in it on a bi-weekly meeting where we're receiving updates, and I believe that someone with AOC is hosting that. Or of course, certainly the board or the county.
Great, thank you.
But yeah, going off of that, the last coordination meeting that I was in last week, I think the Governor Kotek's letter was mentioned and released to us. So that letter is requesting a pause on the pick'em work, and then also that FEMA engage in some sort of coordinating with Oregon agencies because that really wasn't done before the release of this letter. So I haven't heard anything. That was just sent out on September 26th, and I haven't heard what the result of that is yet, but we're aware of that and tracking that letter, and hopefully that results in some extended timelines or something like that. And then I also just wanted to mention Senate Bill 3197, which is the requirement for clear and objective standards for housing in counties. As Amber mentioned earlier, this is an ongoing project to adopt clear and objective standards, which is going to be an interesting intersection with this pick'em project. At least looking at the model code, doesn't totally contain clear and objective standards and is going to affect housing. So I just wanted to mention we're aware of that and we're tracking it. It's probably something that's going to be needed to be resolved in the actual needed housing project. But I just wanted to flag that that's a potential conflict between FEMA, what FEMA's requiring, and the state statute for needed housing. And I think that's all I have, but I'm happy to take questions.
That's a lot.
Yeah.
But you've made it very concise in
Yeah,
an
it's good.
understandable fashion. Well done.
Questions, comments,
A theoretical question, excuse me for that. I mean, if we're looking at one of these pick'ems, which Deschutes County, those guys, they did that, I guess, number 2, their permit by permit consideration.
They did
the model code.
The model code was which one?
which is the first one.
Oh, okay. So let's say, for example, we do a number 2, a permit by permit consideration, but that requires a habitat assessment and a mitigation plan. Is there a way, as we're thinking forward, if this is the way we want to go, let's say, that a person in a certain floodplain region who was the first to the table to have a mitigation or a habitat plan, could that plan also, for the cost of that, be also viable for other applicants within the same floodplain region? So that each person who wants to build a house, let's say there's 3 people in this, I'm just making a story up here. Maybe there's 3 person in a specific floodplain range that the habitat assessment and the mitigation plan is similar. Could they share that same information, that template somehow, so that each person, so we're not making each party more expensive and make them do the same thing over? That's just some consideration.
Potentially, I think it would really depend on the scope of the habitat assessment and the person who's doing the habitat assessment. What is the scope of what they're looking at? Are they looking at the property scale? Are they looking at a subdivision scale? Are they looking at a neighborhood? So I mean, that could be possible. I think it would take a lot of forethought on an applicant or a group of applicants to say, oh, we're all planning to build a house in this one area. let's get a habitat assessment together that assesses this entire area instead of having it just look at my property individually. I don't know that there's, I mean, we could work on facilitate, I'm not sure how the county would facilitate something like that, but I think it's possible.
Like a scalable template. That's, you have blanks to fill in, but here's the basic template.
Right, and I'm not thinking as a county, we're gonna approve a subdivision of floodplain. I mean, that's kind of a challenge. But I'm thinking, if there's just a handful of people, and we're not talking a lot of properties here either. I mean, we're talking about some specific ones. Well, this was one I mentioned, but 13,000 properties, we're not talking all those people are gonna wanna get and build.
Yeah,
So, I mean, the impact is fairly minimal, but I think what I hear Commissioner Parr and the other commissioners saying is that to be a little proactive, to make the process simpler and maybe shareable might be the way to make it more clear and objective.
what I think will probably happen, is that so I'm not fully clear on who will actually be doing the habitat assessment and mitigation plans, because that's not spoken to in the habitat assessment guide. They throw out some ideas of who could do this work, but there's no requirement that like a certain certified person has to do this work. So my guess would be that some local companies are going to start getting requests for this, and then they're going to come up with a template of sorts for doing that work. They're going to become more familiar as they get more of these requests. That's what I think will happen if we did the permit by permit basis.
Commissioner Buck.
So just to clarify, if we did the model code, people don't have to do this.
I don't believe that's necessarily true. I think there would still need to be they wouldn't be submitting a full-blown habitat assessment that they're having a consultant do on their own. There are sideboards with the model code, but I do still think that some sort of professional is going to need to be involved even to comply with the model code.
Okay.
So, seeing any other questions, what are, I mean, we're waiting to see if there's a response from the governor. I noticed she copied our congressional delegation, so hopefully we're getting some support with the agency, but we have to, what happens if December 1st hits and we don't have something, we're not ready?
Well, the letter indicates that if we don't indicate to FEMA what pathway we're choosing, we default to permit by permit. My understanding is that they're going to start doing some auditing of our floodplain program. Sorry, I had.
Yeah. So I guess what I'm asking is if it defaults because we are waiting for some other kind of resolution, then we have to start going down that path of implementing a permit by permit, and we could still change course. You can still change your approach.
I believe so.
Okay.
Yeah.
But if they choose to audit our system, that could put us at the end of a very long line and further extended timelines. That's hypothetical. So the model ordinance approach, the first one, to me, at first glimpse, it seems that would be the way to go, because it would probably trigger less eye raising on their part. Eyebrow raising, excuse me.
On FEMA's
On FEMA's part, yeah, so it would attract less attention and allow us to do things in our way.
Yeah, and I think to respond a little bit to that, I think the benefit of the model code is that eventually we will be adopting some sort of model code coming from FEMA once we get to full implementation.
Yeah.
But they have made it clear that the model code that they're suggesting at this point for pre-implementation is not necessarily what is going to be required for full implementation. So I'm anticipating that model code will change for full implementation.
Might be nuances, or it might be vastly.
Yeah.
So we could go through a code amendment and then
Go
If
through
we have
another
to do it
one.
again.
Yeah.
or code amendment.
Mhm.
Making this easy, are they?
Vortex making it a little easier.
Well, she succeeds. Great.
So just questions on our next steps, since we have like a condensed timeline, it feels like. What do you suggest for next meeting?
We could do another, we've talked about doing 2 work sessions on the pickums if the board feels that they need more time to digest the model ordinance or the permit by permit basis. And staff can come back and we can dive in. If the board was leaning towards the model ordinance, I think it would be beneficial to go into that in detail. So we could do another work session on that, or if the board is feeling like they could give direction on which pick'em to go forward with, then we would receive that direction and go forward with the code amendment.
I know for me, I would like a little more. This is what this one would really look like and take, and this is what this one would look like and take from us as an organization, and then also the side by side of the potential impact on. But those are the two. I would want to look at it through both those lenses.
If we have the time to do that, I think absolutely. But
Yeah, is this one of those things where if we're not ready by the first, but we can show we are making sincere efforts to be underway, that's going to be treated differently than if we're just.
I think so, and I would hope so.
Yeah.
There was no really scary language in that letter that said you're gonna be thrown out of the NFIP by this date if you don't do something. I think what I was reading and what I'm feeling from the coordination meetings is that they'll be willing to work with us as long as we're moving towards
Demonstrating
something.
good faith. Yeah, I know Commissioner Farr has a comment, but Director Hurley wants.
We may be opening ourselves up to third-party lawsuit if we have not implemented by the specified date, though.
Okay.
yeah, and just a quick question as to any feeling as to the chance of success of Governor Kotik's letter and any timing on that. That's pretty. I mean, and I need that answer now, please.
I don't know. I hope it lands and we can have
That's-
some extended
That's the best
timelines.
we can do, as we hope. But the third-party lawsuit, where would that come from?
That could come from an environmental group. If we
Right.
approved a permit that isn't in alignment with where the federal statutes
Mhm.
directed us to go.
And it could be
then we
anybody.
can-
It could be a 6th grade class someplace. Yeah, okay.
So we do have some time. We have some pressure
Mhm,
to choose.
mhm. Okay.
But still, at best, it's a moving target. I mean, so if we decided on something by December 1st, it gives us still some wiggle room. If we decide that's not gonna work, we can make a different decision in the future. Is that what I'm hearing? Okay.
Or there's the temporary moratorium to give you a little more time. You know, you could say it's a 6 month moratorium, give yourself time.
Yeah, which is what Clatsop did, right? Yeah.
Well, and that would give time to see what our delegation might be able to leverage with the support of the governor, which would benefit everyone. Commissioner Slater.
Do we know how many properties this affects in Clatsop versus Lane though? I mean, 13,000 is a lot.
It's right in Seaside.
I don't know about Clatsop. I was watching Wasco County's meeting on this topic, and they have a lot less properties. I think it was Wasco and or Benton have many less properties in the floodplain, and then they also were looking at vacant properties in the floodplain, and it was like around 200. It was a significantly less than the area of floodplain that we have in Lane County.
Can I ask a question? Do we have a staff recommendation on the 2 approaches?
I don't have a specific recommendation. I think we talked about it a little bit, that maybe permit by permit would be the preference at this point, just because the model code is really complicated and I've only just started digesting it. We've started digesting it on our own without input from FEMA on how it should be implemented. So I guess before I recommended the model code, we're gonna have the workshops with FEMA in November, and I'm really anxious for those workshops to learn more about what this model code entails.
So really there are 3, I mean, model code or this moratorium option too.
Mhm.
And so do you have any sense of how a moratorium would land in terms of impact on, respondents or applicants? And it doesn't have to be a 6-month, like what is a minimum useful moratorium to be worth going through that, given that we have these other folks advocating on our behalf for a little more time? Is there a potential recommendation about a limited moratorium?
I have not talked to legal counsel about what a moratorium looks like. We issue lots of floodplain permits every week. I don't have an exact number on how many, but doing a moratorium on floodplain permits would have a significant impact on people doing work on their properties.
Chair, we could follow up with a number of floodplain permits and talk with county council about what a moratorium would look like, if that's something that the board would like us to do. Rachel and I had discussed that if you're looking at the model code, preliminarily, what we understand of it, it could require hiring, landscape architect to look at tree locations and the width of trees, a biologist potentially, and other professionals that, a habitat assessment would also require hiring a professional, but have that bit more flexibility to report, so potentially that, that's a consideration. They both require professionals, we think.
Yeah, I think so.
My read, tell me colleagues if this is right, is we might want one more session with a little more specific, I mean, this was an overview and then this, but focused on the specificity of options and their various potential impacts. And then if staff is prepared with a recommendation, I think that would be welcome, or at least a little more of another session with a little more deep dive into what the options really would, how they would really play out. So we're making a better, more informed decision.
And it feels
One
like
more time to think
model
about it.
ordinance or moratorium are probably the two most logical.
Or permit by permit, because that's what it's going to default to. We should understand that.
We should understand what it is, if
Mhm.
that is a default, yeah.
Yeah.
Okay.
Yeah, just, so I guess going forward too, when we're looking at permit by permit and this whole habitat effect, I mean, whose standard dictates if the habitat and mitigation assessment is enough? I mean, you started to talk about, it could be a tree guy and a landscape guy and a this guy. I mean, do we define that standard as a county, or does FEMA tell us you gotta have X, Y, and Z professionals come and take a peek at it? That's really vague right now.
That's part of the problem, is FEMA hasn't given us that information or guidance. The model code has some pure-ish and objective-ish standards on what
It's a legal term. Yeah.
Tell us what you're gonna do, we'll tell you if it's wrong.
On what standards we should be meeting. That's in the model code. There are some clear and objective standards on how we should be mitigating the impacts. But the model code doesn't designate any professional to do that work. But just in my reading of the code, is it would take a professional to even figure out what to propose to mitigate the effects or to achieve those standards. And I think the same thing exists for the permit by permit and habitat assessment guide, is it doesn't outline who's going to do that work, and it also doesn't outline clear benchmarks. But we understand that some professional would have to write something that told us it was meeting no net loss.
Is this some of the clarity you're hoping to gain through the workshops that you said FEMA is hosting?
Yeah.
But those are in November.
Yeah.
And we have a December 1st timeline, and we're down the last 2 weeks of the month of November.
We could skip that, we could be up.
We're gonna have to make a choice before she knows all the answers, unfortunately.
When is that seminar?
I think I'm able to attend them in November. It was maybe the second and third week of November was when I.
So we won't have.
So I can I can talk more about the model code now if that's something that the board wants to hear. I don't know if we have a lot of time for that.
We don't, I mean, I think the side by side, earlier it seemed like people were saying, yes, let's have a presentation that's just focused on option A, option B.
Yeah.
Option C, the impacts of a moratorium. So we really are just focused on that. Is that still what people are saying?
I agree. And my brain's a little full right now.
Mhm. And I don't know, Steve, can you work with Tanya on seeing when we could get that on the agenda? How much time would you recommend for a presentation on that?
Probably the length of this presentation, so maybe another hour.
or something?
Yeah,
Before or after the workshops?
well,
it
it's
has
gonna have to be
before.
before the workshops, I think, so
Mhm.
I'll do my best
Yeah.
on what I know.
So maybe that last week of October, 29 or 30. maybe get something
Is that
going.
workshop being held anywhere else in the country before it comes here, or is that just a,
FEMA proposed, several dates, in late October and November. I don't have them specifically in my brain, but they're virtual and
do you have any colleague that you know that would do an earlier one that would give you the
Yeah, we
bullet
can-
points maybe?
we can explore that, yeah. Or I can look at what the earlier dates were. I feel like it was October 16th was the earliest one.
Do we have any mapping of where the 130,000 acres, 13,000 properties are?
It's in the floodplain. It's our regulatory floodplain, our
You
adopted.
mean
floodplain.
geographically speaking?
Geographically, I mean, where are they, where in Lane County?
We can show that on our interactive
Yeah.
mapping.
That would be, I just think that would be
Yeah.
really helpful to know, like, what is the area that we're talking about?
Yeah, they're gonna be close to watersheds for sure.
Commissioner Sanders?
Yeah, and do they look at floodway the same as floodplain, or they keep them separate?
It's the same, yeah.
all-
You know, you think about Wasco and Benton County.
Okay. Anything?
Do you want some more for the brain?
Do you need any?
I
excuse me,
gotta
Commissioner-
digest that.
Anything else from staff? Is that
That
very
sounds good.
helpful?
Yeah.
Great job, thank you.
Great.
Thank
Yeah,
you.
Good job.
Right, well, then that concludes the item and concludes our business for the week. So at the sound of my gavel, we will be adjourned until next Tuesday, October 15th. We are adjourned.